Very much. Very interesting perspectives, and certainly worthy of lots of consideration. I have one question for Ms. Lee. I'm interested, we hear a lot that by creating CCPA rather, we are going to destroy the business model of companies. The companies are going to go out of business. I think Mr. McTaggart pointed out that in the 50s, the automobile industry professed that we were destroying their business model by calling for safety, and tobacco, and he left out the oil industry. That's another one, and trying to create renewables. But I would be remiss on behalf of my communities not to point to the oil industry. I'm wondering, the fact that companies have already got to comply with GDPR, the fact that we now have in California this regulation, companies that are complying or trying to comply with GDPR, are they at a disadvantage, or are they in fact have sort of a leg up in the efforts to comply with CCPA because they are already working towards compliance with a different but in the efforts to comply with CCPA because they are already working towards compliance with a different but perhaps in many ways more stringent set of requirements.
Sure, and it's going to depend. As I mentioned, not every company, first of all, not every company subject to CCPA was subject to GDPR. So the companies who weren't, they're starting from scratch. The companies who did take steps, to the extent that they conducted those enterprise-wide assessments, and I do think that's where a lot of the legwork takes place. It's really, when you kind of get into the weeds at a company and realize the format in which data is collected. I mean, imagine a company that initially started selling, widgets, and then, selling things like through mail became obsolete, and so now they've pivoted, now they have a digital platform, and maybe they've acquired some companies. Those kind of companies have lots of different databases. They have different owners and stakeholders. And so it's a process just to kind of collect and figure out what information we have, how are we using it across the company. If they weren't required to kind of engage in that assessment before, it just takes time to kind of go through that process. So for companies who did that process for the GDPR, I do think that they are, far along the way of the process. Like I said, there are other questions that they need to answer here, but having gone through some of the GDPR process, I think does put you at an advantage. And I don't know that, companies will go out of business. I think it'll depend on the size, but I do think you have kind of two considerations to keep in mind. Regulations like this always favor larger companies who have more resources. That's just a fact of the matter. So the bigger you are, the easier it is for you to comply and pivot or take the risk in some cases of lawsuits, because that might be built into your business model. And I do think that with this, and this applies across the board to a number of industries, but it's clear that the desire here is to address the situation of data being shared online. And I think it is the advertising and ad tech industry that will be hit hardest. Similar to under GDPR, I think they were hit hardest by that law as well. And you saw a lot of those companies pulling out of the EU. A lot of targeted advertising and online advertising has been reduced. And after GDPR, I think they were hit hardest by that law as well. And you saw a lot of those companies pulling out of the EU. A lot of targeted advertising and online advertising has been reduced. And in the EU, regulators hate the concept of the ad-supported internet, and so they're not particularly interested in that business, but here we've supported it, and I think consumers do get a benefit from visiting sites and not having to pay for it. I mean, I understand there's a balance, and I think, like I said, companies understand there needs to be a balance with privacy, but it's important to keep in mind that some of those models will shift based on how the law is constructed.
And so some of the models will shift. As I understand it, most of the collection of data comes from these bigger entities where people tend to do more business, platforms like Facebook, for example. And one of the things I don't know, neither Senator Dodd nor Senator Stern were here at the beginning, and perhaps you know this, but one of the most outrageous misuses of information was discussed, and I just have to repeat it because I can't think of anything more violating of one's privacy than this example. So the Fitbits now, women who are seeking to get pregnant will put into the Fitbit their menstrual cycle, and the Fitbit will tell them when they are ovulating. That information, unbeknownst to these women, is being transmitted as we speak to Facebook. They are actually acquiring that information without the permission or the knowledge or consent of these women who are using the Fitbit to perhaps assist them in finding out, having more information about when they ovulate in the desire to have children. And my point was, and I think this is really true, if you don't want your mother to know that you're trying to have children, why in the world would you want Facebook or some other stranger to have that information? And I think that for the young women here, or for the mothers and grandmothers, when we always want to know, so, the children will tell you when they're ready to tell you. And yet Facebook is going to know that, and isn't that something that is just beyond the pale? And something that we need to address. And that's just one example. We mentioned Cambridge Analytica as well as another. So that is just beyond the pale. And something that we need to address. And that's just one example. We mentioned Cambridge Analytica as well as another. So I think that is critically important. Ms. Lee, did you want to respond?
Just to respond to that quickly, I do want to note that the law doesn't distinguish. I think when we talk about these examples, we're talking about, it typically involves sensitive data, health data, financial data, or vulnerable classes like children, for example, or it involves the harm caused by that data. And those issues aren't particularly addressed. There's no kind of distinction between personal information that is sensitive and just kind of run-of-the-mill personal information that might have, less of an impact on an individual. So I think it might be helpful to create a distinction. There might be different levels of protection that are required when data is either sensitive or it starts off, as an email address and then sensitive pieces of data are appended to it, because I think that gets at your concern. And I don't think anyone would disagree that, your health information, I'm a consumer as well. I don't want my health information shared with a third party without my knowledge. And so I think that's a valid consideration. I will say also that, yes, big companies are the consumer-facing, or in many cases, big companies are the consumer-facing companies, but the ad tech ecosystem is a massive ecosystem. There are a number of third-party players that are operating, and I know that's part of the issue, again, bringing light, but it's not just sort of these big companies. I think the law is addressed to them, but has implications for a number of smaller companies as well.
Again, it focuses, though, on the consumer rights. And as we were talking, we need to balance them. But I think the consumer rights, as a matter of public policy, are the concern, or should be the concern, of us here in the legislature. Did you have a comment, Senator Allen? I set this one up for you, so I'm hoping you do.
Terrible joke about you and I laugh a lot about. There'd be a market for Jewish mothers paying for their son-in-laws, for their daughter-in-laws, information. That I'm sure there's a market there. So So all the more reason to prevent it from from being allowed to be sold. I mean, it really is extraordinary, and I guess it's shocking, really. And you know, we all want, you know, we're proud of these tech businesses that are growing in California and you know, providing all sorts of access to information. But at the same time, there's a line that has been crossed over and over again by some of our folks here. And you know, I was interested in Ms. De La Torre, if you have any comments about you know, political the use of social media for political campaigns and you know, some of the recent things that have been happening, at least here in the United States, with regards to foreign intervention in our elections. Are, you know, how does this interplay in Europe? I know there's been news of similar kind of big data attempts with some of the domestic politics of European countries. How is this playing into the conversation about GDPR, and what should we be thinking about in terms of foreign intervention in our political system, and the use of these platforms for that?
Well, from my personal comment, but that's obviously a really big subject. So GDPR predates this news that we have been receiving both in Europe and in the US about the use of information to target political advertisement and manipulate people's opinions. But as a data protection law, it is fundamental from the European perspective in terms of enforcement. The Information Commissioner of the UK, the ICO, was really involved in the whole situation with Cambridge Analytica in the UK from the beginning. I know that many of the resources have been used to investigate this situation. Obviously, from a data protection Many of the resources have been used to investigate this situation. Obviously, from a data protection perspective in Europe, the conduct was against the law. It's not even a question, right? When I provided my remarks, I mentioned this idea of data protection trying to outlaw unethical uses of data. That was under European law an unethical use of data, and therefore it was illegal.
So what was the law that was violated in Europe? And I assume you're saying that it wasn't necessarily against the law here in the United States.
Well, you know, it's a big subject, right? But I don't know of any privacy law that was violated by the conduct in the U.S. There are many laws I'm not aware of, so there might be other laws that have been violated. But data protection law clearly was one of the laws that was identified in Europe as a law that had been violated, and the consequences of that are quite interesting. One of the things that we don't generally realize from the U.S. perspective is that because Europeans take this fundamental approach about data protection, the fact that Cambridge Analytica was UK-based means that for all their activities, they are subject to European data protection law, which means that any U.S. citizen that wants to exercise a right to access against Cambridge Analytica will be able to do so under European law. I don't know that many people did, but the GDPR grants anybody that right because it's a European company if they consider that their companies have to abide by their laws, regardless of whether they have data of Europeans or not. So, and from the perspective of, you know, their activities, definitely they were against the law of the UK at the time, and the outcome is likely that they will, you know, disappear as an organization. If I can use a joke that I have used in the past to kind of highlight this for my students is, obviously the conduct was illegal clearly in Europe. I'm not sure that it was clearly illegal in the US. But many years ago, when I came to this country, one of the things that I did was interpret. And I remember at a hearing where a defendant was read his rights, he was asked, do you stand accused of being under the influence of controlled substances, and how do you plead? And he said, I plead not guilty, so I translated for the judge, not guilty. And the judge said, okay, let me open the file. He says here, on March 5th, you were found by the police and you were taken to the prison and your blood resulted as positive of methamphetamine. I said, oh, yes, I was using methamphetamine. And they just said, but you're pleading not guilty to controlled substances. And he said, well, methamphetamine is not under control. So the point is that one thing is to prohibit the conduct, and a different thing is to avoid the conduct, right? So what is clear to me is that in Europe, the conduct was prohibited. It was not avoided.
It was not avoided?
Cambridge Analytica had also an influence in Brexit. And so it's clear that it also took place regarding European elections.
Right. Yeah. Okay.
Hard to put your arms around. And but,
well,
yeah.
I have to keep their attention.
All right. Senator Stern, did you have a question followed by the Vice Chair?
Question, not a joke, although I know this is all about jokes. Since May, the GDPR regs took effect. How much has the private right of action been utilized as an enforcement mechanism?
So that's an open question. There has been a lot of highlight over this idea that GDPR grants a private right of action, and it is true. But you have to realize that Europe has not been harmonized in the same way the U.S. has been harmonized. So Europe doesn't have a federal court. So all of these private rights will have to be fought and won over the rights of the independent countries. So, for example, you might have a court in Spain decide that a person doesn't have a standing in the same grounds that we find typically here. And that reasoning might be pretty different from what you find in Poland or Italy. So I think it's a little too early to evaluate what the result is going to be of this private right of action, but it's definitely enabled by GDPR. We just don't know how it's going to play out.
Do you have any sense, quantity-wise, though, of how many filings have been made overall? Is anyone sort of tracking that?
I am not aware of anybody that has been tracking that.
Okay, so, but when it says, in our background memo, it says, private right of action under CCPA limited to data breaches only, but that it just says yes for GDPR. You're saying this question of standing and jurisdiction ends up as the
right of action. I just don't know how effective the private right of action is going to be in terms of actually driving outcomes for the plaintiffs, because it's going to depend on the procedural rules of the independent countries that form the European Union.
So in other words, the limitations may not be obvious, but they'll be dictated based on the sort of however the civil procedure works in whatever that particular nation. Is that sort of how the governance structure works in Europe?
Exactly. What I anticipate is that because we had the same challenge here with private right of action over privacy, where it's difficult to prove damages, and that has been an effective barrier to, I guess, an effective restraint on the ability of individuals to actually obtain positive outcomes when they an effective restraint on the ability of individuals to actually obtain positive outcomes when they sue for a privacy violation. I think that we might find the same thing at the European level, but it is really difficult for me to anticipate because I only know the laws of Spain, quite honestly, and it could work in very different ways in the different jurisdictions.
Can I?
Yeah, do you mind, Ms. Lee? Thank you.
Sure, and this isn't about private right, but we have heard that hundreds of complaints have been filed with the data protection authorities, and I think that's the channel that a lot of individuals are going through. So what we've heard is that what they're doing now is going through evaluating those complaints, and we expect to see enforcement take place over the course of this year as they kind of go through all the different complaints that have been filed. So my understanding is that many of the issues are being dealt with at the DPA level, but the GDPR did give what is similar to the class action. I don't think there really is a concept of class action previously in the EU, but it did give this concept of bringing a collective action under the GDPR, and there have been a couple of collective actions filed by consumer advocate groups, one led by Max Schrems, who is a guy who challenged the U.S. EU safe harbor, and then Johnny Bravo also has a collective action that's being brought mostly against the big tech companies.
And are they mutually exclusive? Like, can you be party to a some kind of collective action like that and file with the DPA as well, or are they mutually exclusive? Like, do you have to sort of pursue an administrative or regulatory path and then pursue, or they can happen in parallel? Okay.
And effectively, historically, most of the complaints for data protection violations have gone through the data protection authorities, and even Max Schrems, his complaint that led to the 50 million fine for Google, he filed it with the Data Protection Authority of France. So it's more typical for data protection law to be enforced through the regulatory agency, through the Consumer Protection Agency, that through independent private right of action.
Okay.
It's an option as well. They can go through the more administrative regulatory process rather than the courts. Okay, thank you. Senator Borges.
So I'm just going to add a little thing to that. So the European right to data protection that is in the Constitution equivalent of the Bill of Rights actually says that you have a right to have an independent authority that will look at your complaints when you raise an issue that has to do with data protection. So that is granted on Europeans, and there's always that recourse, yes.
Thank you, Madam. Being a freshman legislator, my colleagues will oblige me on some of these basic questions, but I met with some folks today that talked about the impact that this legislation is going to have on businesses, and I asked if anyone could quantify or project out some quantifiable data on how many businesses will go under for something like this. And of course, I have not yet seen anything about that, but if we were to use an example of, let's say, a retailer, and a retailer gathers data, and that retailer is the primary user of that data. And then that primary user sells it or discloses that information to secondary users. So I guess my question is, if certain industries are fearful that they will have a reduction in business or market share, is this a mitigatable situation when the primary
a little too early to evaluate what the result is going to be. This private right of action, but it's definitely enabled by GDPR. We just don't know how it's going to play out.
Do you have any sense, quantity-wise, though, of how many filings have been made overall? Is anyone sort of tracking that?
I am not aware of anybody that has been tracking that.
Okay, so, but when it says, in our background memo, it says private right of action under CCPA limited to data breaches only, but that it just says yes for GDPR. You're saying this question of standing and jurisdiction?
No,
ends up as the...
Private right of action, I just don't know how effective the private right of action is going to be in terms of actually driving outcomes for the plaintiffs, because it's going to depend on the procedural rules of the independent countries that form the European Union.
So in other words, the limitations may not be obvious, but they'll be dictated based on the sort of however the civil procedure works in whatever that particular nation. Is that sort of how the governance structure works in Europe?
Exactly. What I anticipate is that because we had the same challenge here with private right of action over privacy, where it's difficult to prove damages, and that has been an effective barrier to, I guess, an effective restraint on the ability of individuals to actually obtain positive outcomes when they sue for a privacy violation. I think that we might find the same thing at the European level, but it is really difficult for me to anticipate because I only know the laws of Spain, quite honestly, and it could work in very different ways in the different jurisdictions.
Can I?
Yeah, do you mind, Ms. Lee? Thank you.
Sure, and this isn't about private right, but we have heard that hundreds of complaints have been filed with the data protection authorities, and I think that's the channel that a lot of individuals are going through. So what we've heard is that what they're doing now is going through evaluating those complaints, and we expect to see enforcement take place over the course of this year as they kind of go through all the different complaints that have been filed. So my understanding is that many of the issues are being dealt with at the DPA level, but the GDPR did give what is similar to the class action. I don't think there really is a concept of class action previously in the EU, but it did give this concept of bringing a collective action under the GDPR, and there have been a couple of collective actions filed by consumer advocate groups, one led by Max Schrems, who is a guy who challenged the US-EU safe harbor, and then Johnny Bravo also has a collective action that's being brought mostly against the big tech companies.
And are they mutually exclusive? Like, can you be party to a some kind of collective action like that and file with the DPA as well, or are they mutually exclusive? Like, do you have to sort of pursue an administrative or regulatory path and then pursue, or they can happen in parallel? Okay.
And effectively, historically, most of the complaints for data protection violations have gone through the data protection authorities, and even Max Schrems, his complaint that led to the 50 million fine for Google, he filed it with the Data Protection Authority of France. So it's more typical for data protection law to be enforced through the regulatory agency, through the Consumer Protection Agency, than through independent private right of action.
Okay.
It's an option as well. They can go through the more administrative regulatory process rather than the courts. Okay, thank you. Senator Borges.
So I'm just going to add a little thing to that. So the European right to data protection that is in the Constitution equivalent of the Bill of Rights actually says that you have a right to have an independent authority that will look at your complaints when you raise an issue that has to do with data protection. So that is granted on Europeans, and there's always that recourse, yes.
Thank you, Madam. Being a freshman legislator, my colleagues will oblige me on some of these basic questions, but I met with some folks today that talked about the impact that this legislation is going to have on businesses, and I asked if anyone could quantify or project out some quantifiable data on how many businesses will go under for something like this. And of course, I have not yet seen anything about that, but if we were to use an example of, let's say, a retailer, and a retailer gathers data, and that retailer is the primary user of that data. And then that primary user sells it or discloses that information to secondary users. So I guess my question is, if certain industries are fearful that they will have a reduction in business or market share, is this a mitigatable situation when the primary user can look upon that data and make either retaining professionals to do so or themselves look upon the purchasing patterns of those individuals and maybe even the consumer profiles that come about from that gathered information, and in a disaggregated format they could then sell or disclose that information as long as it's disaggregated. Is that correct? Maybe, I don't know, Ms. Johnson, maybe, I think you...
A company could take aggregated and de-identified information
Yep.
and share. So the CCPA does have exemptions that allow for businesses
to do exactly that.
Do things with de-identified, and
that means they're still able to understand their market behavior.
you wouldn't be able to identify the individual, though.
You would be able to identify.
You shouldn't.
Exactly. Right. But what I'm saying is that if we're hearing that market share will be lost, businesses may go under, I'm wondering to what extent is that accurate if we understand that you can still understand customer behavior and purchasing profiles, put that back into the system. It's just the purchasing profile, just not the individual who is known.
Right.
Is that fair?
I think that's fair. If you've appropriately de-identified or aggregated the data, you can still glean a lot of insights from it as a business, and you're still able to do that under the CCPA.
I'm sorry.
Yeah, I think, and that might be covered under the concept of pseudonymized data. Maybe that's what you're referring to, so that you can have data that is either hashed or masked, so that you don't have access to the identifiable pieces of the data, but you have access to the rest of the profile information.
Personally sanitized.
Right, exactly. And I think that is generally covered, but it's not sort of as specifically identified as it is under the GDPR. So that is one place where there could be clarification if data is shared in a pseudonymized format, that might allow more leeway for some of these business transactions.
I would just note, I think pseudonymized is different than de-identified and aggregated, and you can sometimes tell the individual tell the identity of an individual more easily with pseudonymized data, and that's why pseudonymized.
So
Pseudonyms?
There is very good research that the Future of Privacy Forum put forward a few years ago that kind of explains this spectrum of data from fully personal data to fully anonymized data. And it's like a degree of grace, right? Mm-hmm. The one thing that I wanted to clarify from the European perspective is that Europe doesn't prohibit the sale of data. It just prohibits the sale of data for unethical purposes. One good example that I could offer is, for example, where we might want to hire a service that lets us know that our information has been compromised online. For that service to be able to provide us the information, they typically will have to go to a company that specializes in collecting this information and buy that information from them. That's an ethical use of data, and it will be allowed under European law. So there's no blanket prohibition against sales under the European regime.
Thank you. I think at this point, obviously, the devil's always in the details, and there are a lot of details here, maybe a few devils, but certainly thank you for sort of setting the stage for us, setting the table on some of these issues, some of the practical problems. We obviously are going to look at tightening this up. Nobody wants to inhibit innovation. On the other hand, we do have privacy rights that we want to protect as well. So with that, I thank you all for your testimony and appreciate the insights you've provided with us today. Thank you so much. Our next panel, we are going to look at stakeholder insights on the state of the CCPA. We'll have Sarah Boot, who is the policy advocate with the California Chamber of Commerce, and Maureen Mahoney, who is a policy analyst with Consumer Reports. We are not moving with the alacrity I had hoped, so if we could keep you each to 10 minutes on your comments, would certainly appreciate that. And we'll start with Ms. Boot.
Good afternoon, Madam Chair and members. I'm Sarah Boot, testifying on behalf of Cal Chamber.
And if you would speak into the microphone, so this is also available to folks at home, so let's make sure they can hear you.
Thank you. Yes. We represent California businesses across every industry, including over 14,000 small businesses. As you know, CCPA passed through a legislative process in just 1 week due to the impending deadline to remove the initiative from the ballot. There was not an opportunity for diverse stakeholder input, and the result is a law that can be confusing and that presents some serious privacy concerns and operational challenges. Last June, when the law was passed, the fact that it needs fixes was not controversial. The authors noted there would need to be some fixes, and numerous legislators signed on to a letter stating that while they agreed with the bill's expansion of privacy rights, they were concerned with how quickly it passed and expected to be able to work on reasonable fixes going forward. Unfortunately, since that time, there's been a narrative that any changes to this law requested by business would be rolling back privacy rights, but that's not true. And the narrative that this law only applies to big tech and data brokers isn't true either. The CCPA applies to a third very broad category of businesses, any business that annually receives the personal information of 50,000 or more consumers, households, or devices. It turns out 50,000 pieces of data is not a lot, given that one consumer can be counted multiple times, and given the CCPA's broad definition of personal information, which includes IP addresses and so much more. For example, the CCPA applies to businesses with 50,000 website visitors per year. If a business has an average of 137 unique online visitors per day, it will hit that threshold. And just think of all the small businesses that easily conduct an average of 137 transactions per day, which is about 12 transactions per hour in a 12-hour day. You got convenience stores, coffee shops, restaurants. There are very many. The point is that the CCPA covers diversity of businesses and treats them all the same as a handful of large tech giants in this state. So please keep that diversity of business in mind as I outline our concerns today, and please keep an open mind. I'm going to start by discussing 5 fixes necessary to protect consumer data security, privacy, and choice. First, the CCPA requires businesses to provide consumers specific pieces of information the business has collected after receiving a consumer request. But specific pieces of information is not defined. It could mean businesses must transmit highly sensitive information back to consumers, like credit cards or specific internet searches, information consumers already know about themselves. This would create a risk of fraudsters posing as the consumer to get access to this data. To alleviate this risk, a business may need to collect even more information from the requesting consumer to be sure it is sending sensitive information to the right person, especially when a business has no direct consumer relationship with the consumer. This runs counter to privacy goals and could greatly harm consumers. We're requesting a CCPA amendment to limit these risks. Second, the CCPA's references to households and devices in the definition of personal information also present serious risks. As drafted, one member of a household, whether they're an abusive spouse or roommate, seems to be able to access all the specific pieces of information, including credit card information or geolocation data about another member of their household. For example, a household member may request access to specific pieces of information from a grocery store delivery service, thereby exposing another household member's purchase of sensitive items like a pregnancy test. Similarly, one user of a device can request all the specific pieces of information a company has about that particular device, which could reveal private things about another user of that device. The inclusion of households and devices could also infringe on the choices of others. For example, if one household member makes a request to delete all data associated with a household, another household member would be subsequently unable to access their information. Third, the definition of personal information is incredibly overbroad. If not adjusted, it will undermine existing privacy protective practices and impose significant operational costs on businesses. Most people think of personal information as data that could identify someone, like birth dates or social security numbers. The CCPA defines personal information far more broadly as information that, yes, identifies, but also that relates to, describes, is capable of being associated with, or could reasonably be linked to a particular consumer or household. Oddly, this definition creates a reasonable standard for data that can be linked to a person or household, but it doesn't make the same allowance of reasonableness for data that is capable of being associated with them. As a practical matter, this means personal information under the CCPA is any information that could, in theory, be associated with a person or household. So let's put this into context. If I have an online account with a store and I exercise my rights under the CCPA, that store should be able to provide me with my account details or to delete them. But that's only the beginning of what a business is required to do under this law. Let's say I also browse sales on the store's website or fill up shopping carts without logging in, and that store keeps IP addresses to track how consumers use their website, but it doesn't link that data back to a person. Under the CCPA, the store could be required to search for every possible IP address that they could in theory be linked back to me. Similarly, if I made a purchase inside their brick and mortar store, they could be required to search security camera footage to find out where I appear on it. The only way for businesses to comply would be to identify people interacting with their business and store that information together in one place, which would be hugely wasteful and harmful to consumer privacy. We don't believe that was the result intended. The law has an exemption stating that a business is not required to relink data that is not maintained in a manner that would be considered personal information. But under the definition of personal information, basically all data is personal information. So as drafted, the exemption doesn't provide relief, and it should be fixed. Finally, although the definition of personal information is pretty all-encompassing, there are 3 types of data that we believe are not meant to be personal information under the law: aggregate data, de-identified data, and publicly available data. But even these exemptions need adjustments to be meaningful. Under the definition of de-identified, only aggregate data could ever qualify as de-identified, which would discourage businesses from using this privacy protective practice. Additionally, the definition of publicly available information is limited to government records, but then it's further restricted to such records that are used for a purpose that is compatible with the purpose for which the government is maintaining that data. Okay, aside from being confusing and thus inviting unnecessary litigation, this restriction is an unconstitutional limit on free speech, and it should be removed from the law. Fourth, confusing language in the non-discrimination section raises doubts about the legality of loyalty and rewards programs offered by retailers, grocers, hotels, airlines, and others. Consumers love these programs. In fact, 80% of Americans belong to at least one. While we understand the legislative intent is that businesses can continue to offer them, unless the section's clarified, it'll be up to the courts to determine the fate of these programs, and there's no need for that level of uncertainty. Fifth, the CCPA also needs to be clarified to prevent bad actors from opting out of data services used to implement crucial government programs, as well as to prevent identity theft and money laundering. I'm now going to discuss 2 areas of this law that will lead to unnecessary compliance costs for businesses and unintended consequences if not fixed. First, the definition of consumer is any California resident, and without clarification, that could be interpreted to include employees. The operational costs for businesses, especially small businesses, of including employees and job applicants will be exorbitant. Imagine a family-owned restaurant that serves 150 tables a day. Without fixing this definition, it may have to operationalize the CCPA for its kitchen and wait staff in a business with high turnover and low profit margins. Access to personal information in the employment context is already established in California law, but the CCPA would allow a separated spouse who's part of a household to gain access to payroll records. That can't be what the legislature intended. The definition of consumer is also problematic because it includes business representatives in the context of business-to-business interactions. So, for example, a small medical practice that already complies with HIPAA for patient data would be required to honor opt-out and deletion requests from suppliers with whom they email for business purposes, but who never have access to patient data. If not fixed, this will lead to unfortunate unintended consequences. Second, targeted online advertising is another area CCPA was not intended to impact. However, the current language lacks clarity. Online advertising is a privacy protective practice in which no personally identifiable information is being sold. The internet ecosystem depends on it, from small blogs to large publications, including our favorite newspapers. And businesses of all sizes depend on this advertising network to reach consumers. It's an important area we need to clarify. Finally, I will address enforcement. The CCPA creates an onerous private right of action to sue businesses that have suffered a data breach. No proof of injury is required, and the minimum statutory damages awarded could put folks out of business. There should be a safe harbor for businesses that have implemented recognized security standards, but there isn't. And despite this, and despite the other flaws with this law, the business community encouraged legislators to vote for it, which resulted in the unanimous vote. And we did this because we hoped we could fix some of the problems I've mentioned, and because the PRA was limited to the data breach provisions of the law. The law is complicated, it can be confusing, it's not finished.